Hello again. My name is Rebecca Neer and I'm the CEO of Orca Information, and we do background investigations nationwide for employers and landlords and property managers. And this is a continuing YouTube series called Frequently Asked Questions. Now recently a law was passed on June 7th of 2012 called the Fair Tenant Screening Act of Washington State. And basically it said that before you take the money from an applicant for the tenant screening fee, you must provide to them in writing a list of reasons why you may turn them down. You must also disclose to them the company that's going to be doing the background check and what kind of information you're going to be looking at. For example, are you going to be pulling a credit report and reviewing a credit information? Are you going to be pulling criminal records and considering that? Are you going to be looking at references? This needs to be disclosed in writing before accepting money, because accepting money is what's considered possibly hardship for large families that are trying to rent homes or someone of low income. So technically speaking, if you do not charge for the background check, do you indeed need to give them this information in writing? Well, I'm not an attorney, so please remember that. But my professional opinion is, being in this business for many, many years, the tenants, the applicants, go through a lot more than just paying for the background check. It takes a lot of time to shop for an apartment. It takes time to get off of work and to go shop. It takes money. Time is money. So there are other reasons, there are other things that affect the tenants or the applicants besides having to pay for the background check. And so for best practices as a landlord or property manager, I recommend that you always provide an applicant with that information that's required in the Fair Tenant Screening Act. If you're not going to rent to them because they may be a registered sex offender, put it in writing. It's going to help protect you, and it's going to help protect them as well. If you're not going to rent to them because they have an apartment collection, or maybe there was an eviction action against them recently, then you're going to want to see that, but you're also going to want to let them know up front before they take the time out to fill out that rental application and wait for that information to come back and for you to make that decision. So to be fair to them, to be fair to you, make sure that you give them that information up front. I've attended many classes given by police officers. It's the crime-free department that most cities have these days, and the crime-free departments, these police officers, will always tell you in these classes to provide applicants up front with a written tenant selection policy, the reasons why you may or may not rent to them. If you go to a fair housing class, they say the same thing. It's one of the first things they bring up, is to be fair to the applicants and to be fair to you because it saves you time. Give the applicants a clear and concise, as detailed as possible tenant selection policy. Now, we have done previous YouTubes, and on those YouTubes we have described in detail the Fair Tenant Screening Act of Washington State, and we've also provided a basic tenant selection policy, a form that you can utilize. We encourage you to look at those YouTubes and to use those forms. And if you have any further questions, again, call us, 1-800-341-0022. I'm Rebecca, or you can ask for Catherine. Thank you.